Suppose that a criminal statute is clear on its face about what conduct it prohibits. But then the court interprets the statute in a new and unexpected way and applies that interpretation retroactively to the defendant's detriment. Does this violate due process? The United States Supreme Court addressed this question in the 1964 case of Bouie v. City of Columbia. In 1960, Simon Bouie and his friend, both of them black college students, entered Eckerd's drugstore in Columbia, South Carolina, and seated themselves in the lunch counter area. The lunch counter was reserved for white customers only, but there weren't any signs or notices stating that black customers wouldn't be served. After the students sat down, an employee sectioned off the area and posted a No Trespassing sign. Then the manager called the police. When the police arrived, the manager asked the students to leave 2 times, and so did the police. The students refused, so the police arrested them. The students were charged with criminal trespass under a South Carolina statute that defined the prohibited conduct as entering somebody else's property after notice not to enter. The city recorder's court convicted them, and the county court affirmed their convictions on appeal. The students then appealed to the South Carolina Supreme Court, which similarly affirmed their convictions. In doing so, that court interpreted the criminal trespass statute as covering not only the act of entering property after notice not to enter, but also the act of remaining on property after notice to leave. The students appealed once more, this time to the United States Supreme Court.